Welcome everyone to the International Institute for Strategic Studies. The talk today on the proliferation of terror watch lists in the US. As many of you know, at least those who are old enough, the last 15 years has been a huge change in how we, as the public, access commercial aircraft. There were very few names on terror lists 15 years ago, but today there are tens of thousands of names that reside on no-fly lists, and every passenger is vetted prior to departure. This is overseen in the United States by new large government agencies that often work without judicial oversight. These institutions do more than just manage no-fly lists. Their development gives us an insight into how the US seeks to balance CT with its constitutionally protected civil liberties. And unlike the debates over the WikiLeaks or PRISM, this has received rather little public attention. Our speaker today is Dr. Jeffrey Kahn. He's a professor of law at the Dedman School at Southern Methodist University in Texas. He's had an interesting career, a varied one, a PhD in Russian politics initially, and then another one in law, and has also served as a trial attorney from 2003 to 2006 at the Department of Justice. Jeff.
Thank you.
Be speaking on the record, I should say, for about 30 minutes, then we'll open it up for questions. Thanks.
Okay, well, thank you very much for having me here. Originally, I understood that we were going to be in the Lee Kuan Yew conference room, which pleased me greatly because I just flew in this morning from Singapore. So, as if to underscore how significant a change we have had in the world in terms of freedom of movement, a very ancient right, a very old and accepted, established principle in a democratic republic, and an essential human right, I'd say, for almost all the other rights that we believe in, is the freedom of movement, the right to cross borders, and the right to freely move within your own territory. So two questions interest me in my research, and I'll present the answers that I've come up with to you today. The first one is, how do states restrict the free movement of people under suspicion? And the second question is, what stops states like the United States from using the same techniques used to stop freedom of movement to stop other rights? So let me give you the answers right up front. At least from my perspective, the answer to the first question, how do states restrict free movement? Today, it's in the title, watch lists. Watch lists are the vehicle of choice now to stop the free movement of people just about anywhere in the world. But there's an odd sort of change that has happened just as the technology has advanced to the point where air travel is as much a fact of life as computers. And that is that a watch list used to mean a list of people worth watching. That's its original understanding. Now, when we use the word watch list, we don't mean lists for watching people, we mean lists for doing things to people. Action lists, restrictive lists. And this change is very, very significant. It's not a mere semantic change, because what the change suggests is a crossing of borders that we've never crossed before. Back in the day when a watch list was a watch list, there were three different aspects of this border that would come into play, a sort of who, what, and where of government action, when the government was going to move from watching to acting. First, the who. That executive decision was no longer exclusively the executive province. It would be subjected to judicial oversight, a judicial check. The second part of that border was the what. The evidence that the state would use for executive action, whether it's a policeman stopping you or a border guard or something else, was typically more than mere propensity evidence, more than the likelihood of some future action. Because of that judicial check, the evidence was such that it needed to be able to satisfy a much higher standard of review, past action. And that's the third point, the where. Previously, when watch lists would move to action, the watching that was done in secret would move into the public space before a neutral magistrate in a public judicial forum. To take away a right as important as the right to freedom of movement, we demanded open courtrooms, open evidence and a judicial check, because that was the significance of moving from a watch list to an action list. At least in the United States, we don't demand that anymore. As to the second question, what stops the United States from using these same techniques to restrict other rights? The answer is nothing. Absolutely nothing. Not politics. The vast majority of Americans, opinion poll after opinion poll will tell you, like watch lists, believe in the efficacy of no-fly lists, and want to expand them. I recently wrote an op-ed in the New York Times opposing a no-gun list. Only in America will we have a debate about whether to restrict access to guns based on a watch list rather than just, as much of the rest of the world does, prohibit weapons that we don't like. I opposed it because of the nature of the watch list, and I received 1,100 primarily harshly negative comments to that New York Times editorial. Americans believe in watch lists, in large part because the Americans who are answering those polls never think that they're going to be on one. So it's not politics that's stopping this. Therefore, it's not the legislature that's going to do anything about it. The tried and true method is a historical one for checking these sorts of infringements on rights, and that's the lawsuit. And later in the talk, I will bring us round to a historical episode where essentially the same actions that we're taking today were taking place then, except without computers. And the answers then were the same too. Not politics, not the legislature, but lawsuits were what undid what I would say is a pretty substantial infringement on a fundamental human right. This is also the story of a brand new agency. After September 11th, an executive agency was created, not by any act of the legislature, but purely by executive order, called the Terrorist Screening Center. The Terrorist Screening Center is an agency that is housed in the FBI, funded through the FBI, and most of its leadership comes from the FBI, but as you can see from the array of badges and symbols around it, it is to service the entire American intelligence community. And I will, in this talk, briefly describe how it came to be created, what its functions are, how it works, and why you should be very concerned about an agency I suspect many people in this room may never have heard of before today. But, as the good book says, first you shall know them by their deeds. So let me give you a few concrete examples. This is the Ismail family, left to right, father and two sons, and their lawyer on the far right, Julia Harumi Moss of the American Civil Liberties Union. I came to know this family. They figure very prominently in a book I wrote on this subject because the father on the far left and the younger son, Jabbar, sitting next to Ms. Moss, American citizens traveling back home to California, where this picture was taken, were stopped in Hong Kong and told they could not proceed. Mother, younger children were allowed back home, but these two American citizens were told, you're on a watch list, you're going to have to go back to your point of origin, which was in Pakistan, where the family was visiting other family, and work it out with the embassy there. Like most Americans in trouble overseas, they readily assumed that the embassy would help them. But when they got to the embassy, they found waiting for them not diplomatic officials, but FBI agents, who said, if you'd like to return to the United States, your home country, you'll need to pass a polygraph test and answer questions to our satisfaction to make sure that you are safe to go back to the United States. If you'd like a lawyer, you're welcome to have one shipped to you here in Islamabad, but otherwise, we'll just proceed. Well, they fought very hard, and their lawyer fought very hard as well, both in court and in the court of public opinion, and 5 months later, they were allowed to return. That's the effect of watch lists. When they returned, they received this letter, which I certainly don't expect you to be able to read at this distance, but I want to just focus on some of the language in it. If you're familiar with the works of Franz Kafka or maybe George Orwell, this language will be familiar to you. Let me just read and annotate the sentence of most importance. Where it has been determined that a correction to records is warranted, this is the last sentence, and I ask you, Has it been determined that a correction to records is warranted? These records have been modified to address any delay or denial of boarding that you may have experienced. No admission of delay or denial of boarding 5 months after the delay or denial of boarding, as a result of the watch list screening process. Was the delay a result of the watch list screening process? The letter doesn't say. Prior to that operative sentence, we're told in the previous sentence, we, and it's really unclear who we is, because the letter came from the Transportation Security Administration, not the Terrorist Screening Center. We have conducted a review of any applicable records. Were there any applicable records? In consultation with other federal agencies as appropriate. Was it appropriate? From the legal perspective, a beautifully crafted letter. Tells you absolutely nothing at all. But from the point of view of the people receiving the letter, not overly helpful. Others have received those letters or that sort of experience in the past. Some of them will be very familiar to you. Senator Kennedy. Because this is a name-based list, in the spring of 2004, he repeatedly had trouble with his domestic travel because T. Kennedy on the watch list seemed perilously close to any number of suspected IRA operatives, also going by the name T. Kennedy. Cat Stevens, beloved singer, songwriter, also stopped in fall of 2004. This man, Mehmet Egi, a Turkish pilot of long standing, 20 years as a commercial pilot, there he is with his children, suddenly finds himself on the no-fly list. A very dangerous place to be if you're a commercial air pilot. Some of these people were not on the watch list until it was too late. If you recognize that face, you know that's Richard Reed, the infamous shoe bomber. This is Umar Farouk Abdul Muttalib, the underwear bomber, neither of whom were placed on the watch list at the time they attempted some terrifying acts of aviation terrorism. And this man, Ayman Latif. Ayman Latif is a retired U.S. Marine, and his lawsuit, I will end with, to show you the small chips and bytes that are being taken out of this system. Again, not by politics, not by the legislature, but by the lawyers and the victims of the watch lists themselves. Now, let me just point out that the catalyst for all of this, of course, was 9/11. On September 10, 2001, there were 16 names on the Federal Aviation Administration's equivalent of a no-fly list. It was called a security directive, and it contained 16 names of people determined to be too dangerous to fly, a threat, in the language of the regulation, to civil aviation security. This list was distributed to airline desks all across the country by fax paper. Remember fax paper? After 9/11, that security directive power was seized by the FBI, transferred from the FAA to the new agency, the Transportation Security Administration, and filled by the agency that I introduced to you earlier before, the Terrorist Screening Center, with as many names as could be found. Currently, and it's gone in an accordion fashion, large and small, currently there are 64,000 names, unique identifiers on the U.S. no-fly list. And this is a chart, unclassified, you can see, that was given to me by the former director of the Terrorist Screening Center, who very generously consulted to a hostile interview with me, telling me how it works. This is a slide that he used to brief congressional staff on the work of his organization. And this is how the organization works today. As domestic law enforcement in the upper left-hand corner, or our international intelligence community in the lower left-hand corner, acquire information, it is funneled either to the FBI or to the National Counterterrorism Center for collation and administration and putting it into a standardized package, and then all of that is sent to the Terrorist Screening Center. This is primarily a result of the 9/11 Commission's finding that American intelligence was siloed and very selfishly held by the independent agencies of our intelligence community, and this was to correct it. And the way it's corrected is for the Terrorist Screening Center, like a librarian, to hold all of the information in a giant card catalog, the terrorist screening database. This card catalog then is used to access the classified, detailed, substantive information for each person of interest to either domestic or international law enforcement and intelligence gatherers. From that terrorist screening database, the TSC then creates sublists, downstream lists for agencies that it calls its customers. For instance, the Terrorist Screening Center creates a no-fly list for the TSA. So the Terrorist Screening Center creates the list, curates the list, puts names on and off the list, and then the TSA uses the list. The Customs and Border Protection Agency has a list for our borders. The State Department has a list composed for it for visa and passport issues. We have lists that we share with the Five Eyes and other foreign partners. We have lists that are sent to every local, state, and municipal law enforcement agency in our country through the National Crime Information Center, so that if you are stopped for a speeding violation, the computer in the law officer's car can quickly determine whether you are either on the terrorist screening database or one of these sublists. Neither of those are places you'd like to be. So the next question to ask then is, how does one get on the terrorist screening database? What's the standard? The standard has slowly been revealed, first through litigation and then through WikiLeaks. You can download this from WikiLeaks. This is the March 2013 watch listing guidance, but long before that guidance was leaked, 4, 5, 6 years before, lawyers were slowly beginning to uncover what the standard for inclusion is. This is from a declaration that was given by an officer at the Terrorist Screening Center, and this is the operative standard. To be on the mega list, the terrorist screening database from which all other watch lists are derived, a nominator such as the FBI must rely upon objective, articulable intelligence. In other words, you have to be able to speak it, or other information which, based on the totality of the circumstances and taken together with rational inferences from those facts, creates a reasonable suspicion that the individual is known or suspected to be or has been knowingly engaged in conduct constituting a preparation of, an aid of, or related to terrorism or terrorist activities. Each of those words has a special and very broad definition, but I just want to point out the key phrase. All that is needed is a reasonable suspicion that the individual is either a known terrorist, defined to be someone convicted of a terrorist offense, or a suspected terrorist. Well, how is suspected terrorist defined? Well, a suspected terrorist is someone about whom you have a reasonable suspicion that that person may engage in an act of terrorism. So, as one federal judge put it, to be on this list, all that's needed is a reasonable suspicion of a reasonable suspicion. I think in legal terms it's called one step above a hunch. With the totality of circumstances language in there, anybody's name could be put on that list. To give you just one example that was given to me by someone who helped to establish the sub-agencies that are using these lists, many of which are in the Department of Homeland Security, he said, suppose that you were to stumble into a restaurant behind a group and someone in that group dropped his hat, or you noticed that that person had left the lights on in his car across the street. So you lean over and tap the person on the shoulder and say into his ear, your hat, your lights. And unbeknownst to you, that group, already suspected terrorists, are being observed by an FBI agent surveilling them across the street. Now you are under surveillance too, and perhaps your license plate or your bona fides will be acquired. And now, I would say, based on the totality of the circumstances and taken together with rational inferences, we don't know how long we've known each other, do we? Do we, Nick? A reasonable suspicion that the individual is connected with those other individuals. So it's a very broad list, and it's a very sticky list, and once on it, it's very hard to be removed from it. But we've been down this road before, so let me give you just a thumbnail sketch of some history. This person is Mrs. Ruth Shipley, and from 1928 to 1955, she was in charge of the United States Passport Office. at a time when your individual travel overseas required a specially created passport each time. Since this was not the era of planes but the era of ships, you booked passage on a ship, you sought a passport, you traveled, you returned the passport to the State Department. Mrs. Shipley decided whether your travel was, in the language of her day, in the interests of the United States. And if she felt that your travel was not in the interests of the United States, you didn't travel. You could argue with her. Here she is with Secretary of State Dulles. Her office was in the Winder Building, which is a prominent historical building that sits across the street from the White House. She'd be happy to listen to you, but she would never change her mind. Scouring the archives, I never found a single instance of Mrs. Shipley changing her mind. She largely made up her mind based on whether she felt you had communist connections or communist sympathies, because this was, for much of her tenure, the height of the Cold War. At the peak of her time in office, she had files on 12 million Americans. Just to put that into comparison with another person who kept files, J. Edgar Hoover's secret files contained 17,000 pages that were kept in 165 file folders. Mrs. Shipley had 12 million individuals under suspicion, and she kept those in over 1,000 filing cabinets in the Winder Building. Now, where is the terrorist screening center if you want to go to talk to the equivalent of Mrs. Shipley? We know where, this is just a Google Maps image of Washington, D.C., we know where the Pentagon is. We know where the Central Intelligence Agency is. We didn't know where the terrorist screening center was until a complaint was filed to a zoning board about noise about a particular building in a particular suburban location. This is an overview shot of the building, and on the top of it you'll see some very large air conditioning units which were going full blast 24 hours a day, 7 days a week to cool the massive databases that were being used to run the terrorist screening center's watch lists. And it was a noise complaint to the local zoning authority that now brings into geographic space the terrorist screening center. Note in the parking lot that strange sort of sculptor work there by the trees, just off of the, just towards the center if you're moving from the left-hand corner. That's actually an artifact from the World Trade Center, a piece of the distinctive molding that was on that building. And it's meant there to remind individual analysts walking into that building every day just why they're there. Inside the building are other artifacts from the different 9/11 sites. And this is all to go to my point about that border, the who, what, and where, that when the government would move from watching to action in the past meant that we moved from purely executive decisions to executive decisions that were analyzed by neutral magistrates sitting in public spaces using higher levels of evidentiary standards. Not because the agents are willfully getting it wrong. These are very hardworking, very diligent, very highly trained and capable government officials. And I don't wish in the slightest to besmirch them. But to suggest that they have bias is not to malign them, but just to state the obvious. That if you are in that environment, making decisions of this sort, your inclination to call a close question in favor of the individual is remote. And walking past artifacts of September 11th is meant to make it even more remote. I have I'm very fond of a quote from the U.S. Supreme Court Justice Louis Brandeis, who said, "Men born to freedom are ready to take action against outward invaders, but the most insidious and dangerous risks to liberty are from well-meaning, zealous officials without understanding." And it's my argument that the officials in that building are very well-meaning, but without understanding. Their understanding is coming from lawsuits, and here I'll close. The lawsuits are coming from Non-U.S. persons, this is Dr. Rahina Ibrahim, and full disclosure, I testified as an expert witness for the plaintiff in this case. Hers is the only case that has so far actually been decided in a trial. All the other cases have been dismissed or failed to reach the trial stage, but hers reached the trial stage. She was put on a watch list in a particularly egregious way. Prior to an interview with an FBI agent, the FBI agent filled out a form to indicate all the watch lists that he wanted to place Dr. Ibrahim on. She is a Stanford PhD in architecture who had been in the United States for the last 20 years. She had married in the United States. She had raised a family in the United States, but she was a Malaysian national. For reasons that are still unknown, she was brought under suspicion. I suspect that they were for reasons closely aligned to racial profiling. But she was interviewed by an FBI agent who, prior to the interview, filled out a form for the watch list that he wanted to put her on. The problem is he was a very badly trained FBI agent, and he filled out the form in exactly the opposite way that the instructions told him to. Instead of ticking the boxes of the watch list he didn't want her on, because this was an opt-out list, which is already significant, the instinct is that you should be on all the lists, and the FBI agent should opt you out of them. He filled it out the opposite way, thinking that he was putting her on different lists. So she was accidentally put on the no-fly list. It took 8 years of litigation to get to the point where the government actually was ordered by the court to allow the deposition of this FBI agent, who, when presented with this form, then realized his error. It took another 1.5 years to get to trial and get a remedy for Dr. Ibrahim. The judge, infuriated by this level of incompetence, ordered every watch list scrubbed of her name, because although the government would repeatedly say that they had taken her name off of a list, once on these sticky lists, she couldn't completely get herself removed from its web. This is a familiar face now. Ayman Latif, a veteran of the U.S. Marine Corps, who moved to Egypt with his family after his military service and wanted to return to the United States, where he's a citizen, to have a physical exam for veterans benefits. He was told he was on a watch list. He wasn't told why, but he was told if he would talk to the FBI, just like Jabir Ismail did, and become an informant in his community, this watch list problem could be made to go away. He refused, and he lost all of his veterans benefits and was unable to come to the United States. The ACLU filed a lawsuit on his behalf, along with others similarly situated, who said that they too had been, and these are merely allegations in a complaint, they haven't been proven at trial, that they had also been propositioned by FBI agents using this list as a tool of coercion, not to prevent someone dangerous from boarding a plane, but to insert an informant into communities of interest. And that leads to the last few slides. These, you will also recognize, come from the director's unclassified briefing. One of the points he liked to make was, this list is outward looking. It's all about stopping them overseas, stopping them before they can reach the U.S., stopping them at the borders and encountering them should they slip through the web in the United States. An externally focused list, which is typically the way rights are eroded. You start with those who are least able to access the political process to protect their rights, and the freedom of movement, Mr. Healy said, would be eroded in that way, but for a very good reason, to protect civil aviation security or national security. But then he showed this slide. There's the terrorist screening database in the center, the mega list from which all other watch lists are derived. And he showed this slide to show all the good uses that such a watch list could be put to. It could be used to prevent people from boarding an airplane, a no-fly list. It could be used by state and local police. It could be used for passports. It could be used to restrict firearms. It could be used to deny someone a hazmat license, a hazardous materials shipping license, because after all, if someone is too dangerous to fly, Surely they're too dangerous to be in possession of hazardous materials. To work in a port. That's American football in the left-hand corner, the Super Bowl. I'm told, I'm not a big football fan. But the argument was, just as being on an airplane with a terrorist who threatens a bomb is a terrifying experience, so too would be being in a crowded athletic stadium or any other crowded public venue. So I predict in the not too distant future, access to special events like the Super Bowl in the United States will have your ticket keyed, just like your airline tickets are keyed to a watch list. You'll pass through a magnetometer, you'll be subject to a search of your possessions, and if you're on that list, you won't be allowed to travel to that special event. Government benefits, borders, visas, licenses. In the past, being a citizen was an absolute condition. It meant you were entitled to a certain set of rights, and should any of those rights be restricted, they would be restricted by crossing that border, by subjecting the government's argument for action, oftentimes a very good argument, to the eyes of a neutral third-party magistrate in a public forum. But no more does that occur, and no more, I argue, do we talk about citizenship in absolute terms. Because the right to travel is a fundamental right of American citizenship. But now we have citizens of the first class who are not on the watch list, and citizens of the second class who are, not by any act of a court. And we are increasingly finding calls for other forms of second-order, second-class citizenship. To possess a firearm, to have a license for employment. One of the co-plaintiffs in the Latif litigation was someone who, while waiting for his case to come to trial, wanted to drive a bus, but needed a license to drive the bus. The state of Minnesota, where he is a resident, operates a watch list now, keyed to the federal watch list, even though the federal watch list really wasn't designed for issuing bus licenses in Minnesota. But the argument of the Minnesota authorities was, if the federal government thinks he's too dangerous to fly on a plane, why should the state of Minnesota give him a license to drive a public bus? And so citizenship is eroded just a little bit further. Not by any act of Congress, certainly not by any act of a judicial authority, but by executive action. So to conclude, this is a portrait by George Tooker. It's called Government Bureau. And this is the state of affairs that I fear as watch lists take hold in the United States. Faceless bureaucrats, zealous, well-meaning, but without understanding, enforcing a series of cuts on the citizenship of supplicating citizens, hoping to have some fraction of their rights as citizens allowed to be retained. This, I think, is a big mistake. I wish that my fellow citizens were more attuned to it. I think they'd be more attuned if more of them bought my book, but that's an entirely different question. So I'll leave you with a closing quote from the American cynic H.L. Mencken. There's always an easy solution to every human problem. Neat, plausible, and wrong. Thank you.